if you've tried that and it hasn't worked and you're convinced that divorce is what you have to have, then I would talk to several attorneys and see who you feel most comfortable with, who you think will be able to be your best partner through the process.
Take a girl and a guy, and they fall madly in love and form a family. Sprinkle in some counseling degrees and a doctorate, a dream of transforming relationships as we know it. And 20 years later, we give you power couple Dr. Ray and Jean Ketkodian. And this is Couples Synergy.
And welcome back to another episode of Couples Synergy with Dr. Ray and Jean. Hi, I'm Dr. Ray.
And I'm Jean, and this is our podcast about love, marriage, and relationships.
Please check us out online at couplesynergy.com or on Facebook and Instagram at Couples Synergy. And please subscribe to our podcast and leave us a review or send us any suggestions on topics you'd like to hear more about. And now on to Couples Synergy, an in-depth look at love, marriage, and relationships, where we bring you our experience helping thousands of couples transform their relationships for over 20 years.
You know, everyone says you should work on your relationship, but nobody teaches us how. So we've created this podcast to teach people what they can do to create the relationship they've always dreamed of
with the partner they fell in love with. On today's episode, we welcome Margaret Zuleger. Thank you so much for being on our podcast today. She is an attorney. She does both litigation and collaborative divorce. Thank you for being on our podcast today.
Thank you for having me.
So we want to definitely get into, your area of expertise and kind of why you wanted to go into that field. But before we do that, why don't you tell us a little bit about yourself? How old are you? What do you like to do on your downtime?
I'm 56 years old. I'm an empty nester, so I spend a lot of my time gardening and landscaping. I essentially spend most all weekends outside digging, hauling dirt, building raised beds, tending my plants. And this past winter, I took a master seed starting class, an online class through Growing a Greener World. I'm a little bit of a Joe Lampel groupie. He's this guy who, has a show on a PBS station, and I like everything he does. And so I took his seed starting class. And so this year I started a bunch of seeds in February, tomatoes and eggplant and different things. And so I've planted them all out, and I'm a little obsessed with gardening on my downtime.
That's awesome.
I also love to garden, and we just moved from Illinois to a desert.
Oh,
so
that must be
it's been
different.
really interesting.
Yeah, very different.
So more sage and cactus, but we have some maple trees and we have beautiful roses, but it's very different. I'm trying to figure it out. It's dry here.
Mm-hmm. Yeah.
Love it though. That's awesome. How did you get into becoming a lawyer?
Well, I'd like to say it's because I wanted to help people, but honestly, I didn't realize that that's what I would be doing. I was like 15 years old, and I was in Wisconsin. I lived in Wisconsin at that. I grew up in Wisconsin, then California, but I was in Wisconsin, and I was on a lake with my dad and his cousin and just, family, and his cousin. He was this young guy, and he had a house and a boat, and he seemed like he had such a fun lifestyle. I'm like, what do you do? He said, I'm a lawyer. I'm like, oh, okay, I'll be a lawyer. And then I never just changed my mind. So it's, and when I went to law school, though, I thought I would want to be international, like do, international stuff, because I've lived in France and Italy also, and I was interested in that kind of thing. But then when I got into law school, I seemed to have more of a skill for litigation. And so people would tell me, oh, you're good in litigation, this and that. But my first job out of law school was employment discrimination, actually sexual harassment, so plaintiff side, and I really enjoyed that. I felt I was fighting the good fight on that end. And I did that for 4 years. And then I had my first daughter, and I didn't go back to practicing law for 12 years until I got divorced. And so that's how, and then I had another daughter, and I did have a real estate company in there, but I was mostly home with my daughters, and I really loved that. But when I got divorced, I realized I had to go back to work full time. And so when I asked my marriage counselor for a divorce lawyer recommendation, because I didn't know any divorce lawyers, he said, have you heard about collaborative divorce? And I said, no. And he said, well, why don't you check that out. And so I looked into it, and I decided that I would like to use the collaborative divorce method. And I decided I would go into family law, get trained, and, basically help people through what I was going through. And that's what I've done ever since. So that was in 2000, and I took the training in 2007, but 2008, I've been family law exclusively.
So our
And I
field
do enjoy helping people.
Yeah, our field's kind of the same way, where when you go to school, and people don't really realize this, you just get all the overview, generic kind of thing. There's not specialties in our field or
Right.
your field. But
Right.
then when you start practicing, then you
Mhm.
can specialize in something. And, we decided to specialize in working with couples because, we came from unhealthy relationships. We were passionate about our relationship, and we absolutely hated the way the field worked with couples. How
Mm.
did you decide, like, really to do family law?
Well, basically, because I really had to choose I had to decide what area I was going to go back to law in. So when I go back to employment discrimination, which I really did like, but it's very intense. And I knew I was going to be a single mom of girls 9 and 12 at the time. And I said, I can't, I was living in Schaumburg. I can't go downtown and have the kind of work life I used to have. I can't do, trials and just depositions. I had to be more regular, more, 9 to 5, so that I was available for the girls. And so I just said that I can't go back into that. So what else could I do? And I thought, well, okay, family law. I said, I'm sure I could get the hang of it. I'll work for somebody else, at least for a while, and learn it. And so I just thought of something I could do, and something that I knew about and could probably be passionate about. And it turned out to be true.
Did your experience going through collaborative divorce influence, your desire to do collaborative divorce as an attorney?
Yes, because I actually went through it all at the same time. I was literally starting to take the training as I was going through my own divorce. So I was kind of doing what I was learning at the same time. And my experience of the collaborative divorce, me personally, reinforced that I did want to do it, because it was very amicable, in part because he was already checked out. I mean, so that's kind of a problem. It was easy because he was already gone emotionally. He wasn't trying to slow it down. And so, but we only had 2 meetings, 2 full meetings. We came up with all their agreements, and it was just a really calm and inexpensive way to dissolve a marriage. And it didn't make it worse. Often, litigation can make the relationship even worse. Things aren't wonderful since you're having a divorce anyway, but sometimes the process of litigation, depending on the attorneys you get, can make things even worse. And the collaborative process did not do that. So I thought that was really great. And so I just, it worked for me. And so I know it can work. And, I try to let other people know of the option.
Yeah, can you describe the options? Because I don't think a lot of people know those terms. Collaborative
So
litigation.
Yes. So in a collaborative divorce, both partners have their own attorney, and we meet for a series of settlement meetings until we work out all of our agreements in writing. And only then do we file the petition and get a court date to finalize. So the whole process is taking place outside of court. And at the very beginning of the process, we sign a participation agreement, which makes it a collaborative case. And the participation agreement has a disqualification provision for the attorneys, which means that if anybody basically jumps the gun and goes to court before we're all agreed, then the collaborative process stops, and the attorneys are disqualified from ever becoming the litigators in the case. And so that keeps the attorneys, the collaborative attorneys, keeps their litigation personalities out of the room. There's no threatening, because we can't see what the judge says. The whole case would fall apart if we filed in court. So we're only problem solvers. We're helping find solution. I mean, we're advising our clients, and everybody knows what the law is, what the formulas are for support and things like that. So it's not like it's not an unknown what would happen in court, but we're not the ones that would ever litigate it, argue about it. And so, and in addition, and so it's an out of court process. Except by agreement, you could file sooner, just to kind of stop the maintenance clock, because in Illinois, the duration of maintenance stops, the calculation stops at the date of filing of the petition. So if you have a case that, it's going to be a maintenance case and the person who would be paying maintenance, formerly known as alimony in Illinois, if they're nervous that the maintenance is going to be longer because the process is going to take longer, and if something falls apart, then sometimes by agreement, we will file the petition just to stop that maintenance clock. But we can basically ask the judge to not call us back for status appearances. The first time we're called, we can say this is a collaborative case, and there's a new Illinois Supreme Court rule that actually has sanctioned all of this now, and so we can ask to be put on the collaborative calendar so that we don't have any court appearances. So it's out of court settlement only, and that's the process, as opposed to litigation where the case starts with somebody filing the petition for dissolution of marriage. Then you're in court, and depending on the county, several months later you're going to have your first court appearance, and then after that you're going to be in court basically once a month, or the attorneys are going to be once a month. The first time you're up, the judge will just say, so do we have children? Do you have an allocation judgment together, which is the new term for it used to be called a joint parenting agreement or a joint custody agreement, but there's actually no such thing as custody in Illinois anymore. It's just parenting time and decision making. There's no word custody in the statute anymore. So in a litigated case, you appear the first time and the judge doesn't know anything, and you're not there to really talk about the details of the case. The judge will just want to know that you're both there, you're working on things, and then he or she will say, fine, see you next month. And then you're basically in court on a monthly basis telling the judge either that you're working on it or that you're having problems, in which case you file motions for this or that or the other thing. And it's just I think it's kind of a wasteful use of the client's money, as opposed to collaborative. Like like when I was going through my divorce, I was happy to pay my attorney for actually being in a meeting, for an hour to working on the case, as opposed to just appearing in court and not really advancing the case, but you have to appear. So that's one difference in litigation. Also in litigation, you never talk to the attorneys. I never even usually see my client's spouse, because it's all just through attorneys. And so when there's negotiation back and forth, I'm hearing through the other attorney or letter that, that their client wants X, Y, and Z, but I don't really ever understand why. And I don't really honestly care that much, because I never meet them. I'm not focused on their needs. I'm only concerned with what my client is telling me, what they want, as opposed to the collaborative, where everybody, the spouses in the very first meeting, we give them an opportunity to express what's important to them. What are their needs? What are their interests? What are their goals? What are their concerns? And so we hear both parties what they hope to get through the process and their immediate post-divorce life. And then we can all kind of help them as much as possible, help them come up with their agreements to meet everybody's needs. In a litigation case, I will never hear one word from the heart of what my client's spouse wants or what's important to them. And so I'm not part of a solution in that sense. So that seems a little bit unfortunate, Now
you practiced in the state of Illinois. Do you know if the other states in the country have a collaborative process?
Yes, I think almost all of the states have. I mean, I think all of the states certainly have collaborative practice groups, and they're doing it. I don't know if all of the states. I think only maybe. I don't remember exactly. I did hear recently how many states had actual statutes that identified and the collaborative process as a method, like an alternative dispute resolution method that's approved by that Supreme Court. But I know it's in like 25 different countries, and I think it's in almost all states. Whether it's in the statutes or not, there's a little bit of a delay. Even in Illinois, I think it was only several years ago where we got our Collaborative Practice Act.
Can you talk about,
even though we've been doing it for since 2000, at least 2000 in Illinois.
Can you talk about the term mediation, and what's a mediator and what do they do, and how does that impact either types of divorce?
Sure. So mediation is where you have a neutral third party, the mediator, meet with the couple to help them come up with their agreements. And they're a neutral, so they can't give advice to either party. And even if they're attorneys, they can't give advice because they're neutral. So they can't. So if one of the parties is starting to agree to something that mediator, even if they're an attorney, knows the judge would never order, they can't say, "What are you thinking?" A judge would never order that. They can't do that. It's really just kind of coming up with their agreements. And I mean, I'm mediation friendly. It's better than litigation, certainly. But the thing is, with mediation, you don't get done. If it's successful, the mediator will draft a memorandum of understanding with all the financial details, all of the child-related details, but you still need to take all those agreements and turn them into the final documents that actually get submitted to the court. So the marital settlement agreement has the financial information and support and asset and debt division. Allocation has the parenting time and the decision making. Those are the documents you need to actually get divorced. I don't actually do mediation myself. I just do collaboration and litigation, and also where if somebody retains me and their spouse is just unrepresented. But so I do work with me post mediation. People will come to me after they've completed mediation with their memorandum of understanding. I'll read it from my client's perspective, and if there's anything in there I think a judge would never order, I say, okay, listen, it looks like in your mediation you agreed to X, Y, and Z, but a judge would never order that. Do you still want to do that? And they might say, no, I thought I had to, and no, I don't. In which case I have to talk, then we have to go back to the table, or yes, I understand and I want to do it. Okay, great. Then I draft the documents, just basically pulling out all the details. So mediation is a good alternative, but it doesn't get you done. It doesn't get you divorced.
So it isn't part of either of those other two processes?
No.
Okay.
No.
Is there any?
Let me take that back. You can you can be in a litigation case and you can agree to go into attorney assisted mediation, where the parties would retain a mediator, and the mediator would kind of help them get unstuck from where they were. If the attorneys weren't really successful in getting done, like, well, try attorney assisted mediation. Sometimes that means the attorneys will actually be in the room while the mediation is going on, and then you kind of do little breakout rooms to talk about things. Sometimes the attorney's not involved. You just send them to the mediator, see if they can work it out. So that's how mediation can be used in litigation. Also in Illinois, if you don't have an agreement on parenting, pretty soon in the case, the judge will send the parents to mediation on parenting only. It's a mandatory in all the counties. It's mandatory mediation on parenting. So they have to go, I think they have to try like twice, two sessions. And again, if it works, great. Then one of the attorneys drafts the allocation judgment based on whatever agreements. If it doesn't work, it doesn't work. There is anything in Cook County where the judge can send you to financial mediation, but it's fairly new, and I don't think it's really used that much in my experience.
Is there, sometimes, when we're working with a couple and they're heading toward divorce, it seems like they've been educated in a way that I don't know is accurate about you have to wait 6 months, or you have to get a mediator, or you have to do this. Is there any standard thing that the law requires you to do?
Right. In Illinois, you do have to say that you've been living separate and apart within the meaning of the act for 6 months prior to the divorce, the day of the divorce, when the judge actually signs the judgment. But that doesn't mean that you're physically separated. It just means you haven't been living as a couple, husband and wife. You haven't been intimate. You haven't been doing things that husbands and wives do. It's something that's hard to prove and disprove. And it really only serves to be a slight delay if for some reason the couple have come together with their agreements quickly, but one person then at the very end says, well, no, we haven't been separate and apart for 6 months. Okay, fine. Then wait 2 months and then the judge will say, okay, well, when did somebody file a petition? Okay, come back in 2 months. So it can be used possibly as a delay tactic, but it's really just something that is said that's not really tested. But that is Illinois. I know that other states, I believe Virginia, for example, you do have to be living separate in separate residences for 6 months before the divorce is final, but not in Illinois.
Wow.
And then the mediation, there is mandatory mediation on parenting that the judge can order the couple to if it appears that they're not going to be able to come up with their own agreements relatively quickly.
Wow. Okay. What is the average cost of divorce currently that you know?
Well, that really, I hate to say it, but it really depends. It depends on the couple, and conflict is expensive. So the more conflict, the longer it's going to take and the more expensive it is. But I would say on average, maybe if it's not a high conflict case and everybody's pretty much doing what they're supposed to do when they're supposed to do it, maybe like $5,000-6,000 on each side would be an average, but it can be less than that. It can be way more than that. It just depends on how quickly you come up with your agreements and how much conflict there is. And part of that fee is the filing fees, and the filing fees are the same whether it's an attorney filing or a pro se. Pro se is self-represented people, so the filing fee to the clerk of whatever county you're filing in, it's the exact same. And so it's, between the petitioner and the respondent, it's usually around $600 combined, and so that comes out of the retainer as well.
What is the most costly divorce that you've seen?
Oh, I've heard of like $900,000, like almost $1 million.
Mm-hmm.
Yes. I haven't had something that's quite that expensive, but I had one that was pretty, it was pretty bad for my client, but it went on for 2.5 years. I think, it was one of these terrible high conflict cases that actually kind of made me say, I don't want to take high conflict cases anymore. It was draining for everybody. And these poor kids, they had 4 kids, and, like they spent all their money in litigation.
Is that typically because someone's hurt?
Yes.
Mm-hmm.
Yeah. There's, usually kind of like personality disorders and mental health challenges that make people just really unable to let go and move on.
Mm-hmm.
And they want, their desire to hurt their spouse is so strong that they'll do it even if it hurts them too.
Mm-hmm.
Yeah.
And I've had people actually
4
say
years.
that.
Yeah.
Yes. Right.
One of my clients I was seeing individually, actually, he crossed over the $1 million mark.
Yeah.
Divorce.
Mm-hmm.
And yeah, it was like 3-4 years it was being dragged.
Yes. Yep. But even when people say there's nothing to fight about, it will be easy. To me, just because there's nothing to fight about objectively doesn't mean it's going to be easy. I remember I had one case where it was a 6-month marriage. It took 9 months to get divorced because they were fighting over the gift cards. They literally were spending more in attorney's fees than the subject of their disagreements.
Wow.
Yeah.
Gift cards.
That's really tough. Are you able to tell when you first interview a person if they are appropriate for collaborative or not?
I really try, because I don't want to have a failed collaborative case, because I think it is so good in almost every situation that I want people to use it, and then I want the word to spread. The collaborative is a great alternative. So I really try. But if they sound too litigious, like if they use words like, I want to punish them because, that it's all their fault. And, I don't want them to get anything, and just like those kind of extreme statements. Well, first of all, then I'm probably going to refer them to somebody else, because I don't want to be involved in that collaborative or litigation. So the more extreme somebody is saying, like, or is speaking about their desire to hurt their partner, then that's a big red flag for me. If they think that their partner is going to, they say they're going to hide things, they're never going to be transparent. Well, that's also that's not great for collaborative. Although it's not like in litigation things are transparent either. You can lie in both situations, and you fill out your financial affidavit, your disclosures. You can lie, and there's no easy way to find out if somebody's lying. There's not a central database where I can plug in somebody's social security number and see like all of the accounts that they have. So if they're willing to lie in litigation, or in collaborative, they might be willing to, they'll be willing to lie in litigation as well. It's just in collaborative, we don't ever serve subpoenas, on banks to get statements. If anybody wants anything, they get it. That's another one of the foundations of collaborative. It's full transparency, and if anybody wants anything, they get it. There's no saying, no, you're not entitled to that, or you can't look at that. It's full transparency.
We've had some couples that the person who actually wants the divorce wants to be kind about it, and they want to do collaborative, but their partner really doesn't. But they'll go through that whole process and not sign at the end, and then have to shift to new attorneys and go through litigation. And that seems to me what took so long. Those are the real long ones that we know about.
Yeah.
What are your thoughts about that?
Well, again, you try to screen for that. And we really signed that participation agreement in the very first meeting. So somebody who goes through the process and then they can pull the plug. I've had this happen where somebody it was actually my client, unbeknownst to me, they got an attorney and filed the petition in the middle of the collaborative case. We all found out at the same time that they'd filed a petition. again, not transparent, not, not acting in good faith, I wouldn't say. And I don't know how to avoid that other than just try to screen. Collaborative isn't appropriate for everybody. And those of us who love it so much, we have to not, we can't be blinded by our, belief that collaborative is so good that it's, that it's necessarily good for every couple. It's not. If somebody's not willing to be act in good faith and be transparent, it's not going to be good. Sometimes people think they're doing it, sometimes people will agree to do it because they think it's, cheap. It is cheaper than litigation, but cheaper than high conflict litigation, but it's not inexpensive. Also because, so like at the minimum, you have 2 attorneys, 2 clients, but you can also have, and ideally you would also have a coach, a mental health professional who's involved in the process, who meets with the parties, both individually and together, and is also in the meetings to help the discussion along and help any like maybe outbursts that take place, help somebody who has traditionally been silent in the relationship speak up, find their voice in the process, which all helps coming together of the agreements. But that is another professional that you pay. But I think it's money well spent, because I think it usually, if it's necessary, it probably takes away the need for more attorney meetings if the meetings that we do have are more productive because of the coach's presence and the work the coach does with each party outside the meeting. They usually check in and say, how are you feeling about the next meeting coming up? And, do you think there are going to be any hot button issues that I should know about? So if so-and-so says X, are you going to be triggered? And how can I help you manage that if it comes up? So that's really helpful. And we can also have in the collaborative team a financial neutral. And this is really helpful if you have a more complicated marital estate, assets or debts or businesses, things like that. And so the financial neutral, they're the gathering source. The couple works with the financial neutral to do the affidavits and all the document production, and the financial neutral drafts the balance sheet and shows different scenarios, as opposed to the attorneys doing that. If there's no financial neutral, then the attorneys will do that job. But really, a financial neutral, and they're always like either a CPA or there's different designations that you have to be a financial neutral, but they're really the best qualified to do those kinds of analyses. But that's another person you pay. But again, so it's still better than high conflict litigation, sure, where in that situation, you might have you might have like the battle of the experts. Say you have a business valuation. Well, if one side gets a business valuation, the other side is 2. So that's, 10, 15,000 at least per business evaluation. And then the judge will usually split the difference. So it's a big waste of money, as opposed to just having one neutral do the business valuation, and the parties, basically say, well, we'll accept whatever that neutral comes up with, and we're not going to argue about it.
I think that mental health piece is pretty crucial, because when you're talking about the cost of divorce, there's also the emotional cost.
Yes.
Right. Even if a couple has decided mutually that they're going to part ways, there's still a normal grief and loss process that they have to go through. And we have found that, in also in working with couples to help transform their marriage, we've also helped couples go through divorce transition. And we found that when we help couples go through that divorce transition, their divorce process is much shorter and
less damaging.
Yeah. Especially when kids are involved. Right. Helping them deal with that, transition now to a co-parenting relationship.
Right.
Yeah, we call it a brutal transformation. I mean, it's you can't cut anything cleanly. It's like breaking a cake. It's never going to be the nice, this is the line and whatever. There's feelings involved. There's your financial well-being is involved. The health of your children is involved. It's a really, really big thing to go through. And we've helped, and the families that have really stayed with us through that process, they wind up being better co-parents long-term.
Definitely.
And, we usually tell people, if you don't have a collaborative marriage, you are not going to have a collaborative divorce. And to get them to think like that, like if you're collaborative, if you guys are good at decision making, you probably are a good candidate for collaborative.
Right.
If not, if your marriage has been,
fighting and battles,
conflict,
yeah.
Yeah. Right. Yeah, the best collaborative cases are when if you have children, then both parties really they put the children's interests first, and they try to act consistently in the children's best interest. So if they're arguing about something and it's impacting the children, they're more likely to stop and say, wait a second, this is, how is this benefiting the children? It's not. Like, how is this helping us be co-parents after the divorce? It's not. Okay, so let's not go down that road, and let's pivot and find a way to resolve whatever it is we're trying to resolve in a way that does the least amount of emotional damage to the children, and the parents, of course.
All right, I'm going to ask you this question very carefully.
Okay.
You always get nervous when I say that. So, in your field, what are some things that the consumer should be careful of, where maybe the lawyer has their own best interest, or the judge or the system, and it kind of drags this couple through? Because we've seen couples have to actually fire their attorneys and get new ones because the attorneys are revving things up so much that they become aware that they're just pawns in this game.
I think that some attorneys, they promise things in the initial consultation to get the client that they know is not realistic. So they they create unrealistic expectations in their clients, and then they go through the motions of trying to get it, even though they know that's not going to work. And so that just leads to disappointment and frustration, and it's unethical. Like, don't promise things that you can't get, that you're and because conflict is expensive, trying to get unrealistic things is very expensive. Filing motions and having hearings, and then you don't get what you should have known, probably did know you weren't going to get in the first place, and then but you're like, oh, and then just kind of blame it on the judge. That's really bad. So I think promising, like I think if somebody's going to hire an attorney, they should interview several attorneys and be wary of the one attorney that like promises all sorts of things. And when the other attorneys are like, well, that's not realistic, or, like I try to be as honest as I can in terms of what I really think is realistic, because I don't want my client to be disappointed in me when they don't get what they think they should get. And there is a lot of, a lot of people think that they can get things that they really can't, but some attorneys won't tell them that,
Mm-hmm.
And so I think that's it. And also I think clients need to understand that they are the principal. The attorney is the agent. So the principal directs the agent what to do. Sometimes people kind of let their attorneys just control everything, but it's not the attorney's decision, it's the client's decision. The attorney can recommend path A, B, and C, but it's the client who should be deciding that, and not just blindly agree with what the attorney is suggesting. Just again, filing motions that don't really have any realistic chance of success, or filing motions instead of trying to get an agreement, trying to just work out something that's realistic. Talk to the other side. Don't just automatically file a motion. Don't just and like, also I think sometimes like all the discovery that some attorneys do discovery, take depositions and serve interrogatories asking for 3 years of this and that, when there's for no reason. That it's just like something that takes a lot of time, and I think some attorneys do that. So I'd be wary of that.
Yeah, we've seen that.
Yeah, it just inflates the cost. Yeah.
We saw that there was a couple, and they hadn't been married long, and she was filing, he could have cared less, and she was the breadwinner, and she's the one that hired, and it was a collaborative attorney. I don't even know if he was even represented, to be honest with you. And her attorney made her go through all this discovery, almost to the point where she was going to end up paying him maintenance when he was willing to just walk away, just whatever, I got to sign. Yeah, that's a difficult situation. What should the consumer look for when they're doing their initial consultation? What does that look like? How do they find an attorney? What does a consultation cost?
And is there a difference between the large firms versus, just a 1 or 2 person firm?
Oh, well, okay. So I guess, again, I would suggest that people meet with several attorneys and really go with their gut. Any number, most attorneys can bring you through the process. So the question is, who do you want with you during the process? Who do you feel most comfortable with? Who do you think you'll have the best communication with? and choose some, and have that be one of your decision maker, deciding factors. Big firms, big firms tend to be more expensive because they do all sorts of stuff, which doesn't really actually help the client. So, I don't think you necessarily get better service with big firms, but some people feel more comfortable with a big firm. But then big firms just are also known more for papering the other side, serving full discovery when there's no real basis for it. Also in the big firm, you might meet with the partner, but you'll never speak to that person again. The partner will assign the case to some associate, and that's the person that you're really dealing with, but that's not really the person that you chose. Now if things get really complicated, the partner will come in and deal with any kind of crisis that comes up, but that's not really the person that you think you're hiring. I think that's one of the problems. And they're just usually more expensive because they have higher rent downtown versus in the suburbs someplace. So
yeah, we saw someone who first they went through collaborative and he refused to sign at the end, and then he hired the big firm just to mess with her, and then she got dragged. That was a very long, sad one. So how does the initial meeting with an attorney, what does that look like? How does that work?
Okay, yeah, so initial consultation. So some attorneys charge, some don't. I don't, because it's just an opportunity to meet a person and see if we're a good team together. Not every attorney is going to be good for every client, but most attorneys, have initial consultation. You usually fill out some kind of intake form that has basic information, occupation for both parties, the number of children, something about assets and debts, income, just so the attorney has some large overview of what the marital estate might be. And then you just kind of take, I always ask people I have your intake form and thank you very much. So what's brought you to me and how can I maybe help? And then every case, everybody's different. So they, people tend to talk about what's, they're most concerned about. So sometimes I can allay fears right at the beginning. Other times I say, yeah, that is a concern. That will be an issue. And this is what you can possibly do about it. But, I try to be as realistic as possible. But it's just like an opportunity to talk and see if you feel comfortable, if you're being listened to. Most people do ask, how much is it going to cost? How long is it going to take? So I say it depends. I give them some parameters. I said, but it really depends. And the more you can work out on your own, the better for you. On the other hand, if your spouse doesn't want to talk to you about these things, don't press them. This is not going to be helpful. I have that case too. I have a new case now, and he keeps saying she won't talk to me. I'm like, her attorney's saying don't talk. I said that's because we just got started, and if she doesn't want to talk to you, then don't try to talk to her. It's not going to be productive. Most attorneys will run tentative support numbers. We all have this software that we use, so I can plug in your income, his income, her income, number of children. Of course, the number of overnights impacts child support, so you have to make some assumptions. What do you think the parenting schedule is going to be? Because child support is one thing if it's 50-50, for example, and it's something else if it's not. Mm-hmm. And so you have to have that discussion. So they're aware that there's child support's impacted by the number of overnights. But usually attorney can kind of run numbers so you have some idea. That can be disappointing for some people to hear because and some people also think that the father has to keep the mother in the house with the children, which is not the case. So there's a lot of misconceptions that you have to kind of educate the client about.
So from your perspective, how has divorce changed since COVID? Like what are some of the trends that you're seeing, and how has the process changed as well?
Well, the process has changed because it's all remote. Including all my collaborative cases have been only remote during the pandemic, and I don't know if it's even going to change. At first, okay, so when in March of 2020, everything came to a screeching halt. All the court dates just like dropped out of the calendar for a couple months. There was nothing going on. But then Since then, it's been busier. So, I mean, I think that the pandemic has been good for divorce lawyers because it's been hard on families. Being together all the time, I think strained marriages a lot of them have broken under COVID, which maybe wouldn't have broken without the stress of all being together and, that kind of stuff. So I think it's the divorces. I haven't seen the statistics, but just from my own personal observation and my colleagues, it's been a busier time during the pandemic.
How many couples do you think file for divorce, but then end up taking that back and making it work?
Not many. I've had a few cases where, yeah, they did reconcile and we withdrew the petition, but not many. But I think that's because most people don't really even contact an attorney until they've been really thinking about it for a long time. It's a hard decision. So the person who wants the divorce is very unlikely to change their mind because they've kind of already gone through a lot of the process, the grieving process. Which is why also, like, often when you start a divorce, one person is, ready to be done because they've been processing. The other person has been unaware of the problem or just in denial. And so they're totally shocked. So it's kind of like, I kind of have people, picture like a track, like a track. And one person's like almost to the finish line. And the other person has just been like pushed onto the track saying, run. And they want to say, no, stop, slow down. So you really have to wait for the second person to catch up because it's usually pretty lopsided. Usually one person. And so because the person who usually eventually starts the process, they've been thinking about it for a long time and are, in my experience, unlikely to go back. But I don't know. I mean, I have more consultations than I have clients. And so sometimes if I have a consultation, I don't hear from them again. And so maybe they reconcile, they just don't know. So I only know that people actually retain and actually file. They don't turn around very often.
There was a couple you sent us and they're still together. That's kind of what I thought about that. Yeah.
Well, I always ask, like in my initial consultation on my intake form, are you seeing a therapist? Would you like a recommendation? More often than not, people say, no, I don't. We already tried, or I'm done. But if I can, but sometimes if they do say, okay, yeah, I would like to try. So, okay, great. Well, then try that. And if I don't hear from them, okay, well, that's good to know. So good.
I think when we first met you, I think you recommended that it would be a good idea for if both people were willing to come to the consultation together so both people could be educated, understand the process, even though you wouldn't represent both of them. Do you still recommend that?
Yes, to learn about the collaborative process. Yes. So I offer just an initial informational session only. So I don't even want an intake form. I don't want to know anything about their situation because I don't want to conflict myself out of helping either of them. But that's an excellent way to have both parties learn at the same time what the process options are. And so they can see what would work for both of them, which is usually the collaborative process. If they understand the collaborative process, most people will choose that versus litigation. But if they don't hear about it at the same time, that's where it's hard for the second party to say, okay, I hear what you're saying, and okay. So yes, it'd be great if couples would do a consultation together, but the attorney has to be really careful to not conflict themselves out.
And do you have any resources for maybe even your own resources of where someone could get that information even without meeting you?
Yes. Well, my website, zulegerlaw.com, has a section on collaborative and links to both the Collaborative Divorce Illinois group, which is the Illinois group, and the International Academy of Collaborative Professionals, which is the international group. And so I have links on my web page about both of those. And that's a great way to find out from a very objective, neutral source what collaborative is all about.
I think that's a great resource, especially for all of our listeners out there across the world, to be able to look up the international resources. That would be good. And we'll put that link in the show notes as well.
Perfect. Yeah. Yeah. Internet. Yeah. There are, like I said, I think 24 countries in the world that have collaborative processes as an option in their divorce.
And where are you able to practice law?
Just Illinois.
Anywhere in Illinois?
Yeah.
Okay.
Technically,
so
but
it's not by county.
No, I'm in, in Cook and all the collar counties, but I don't go down south or anything like that. It wouldn't.
But if
I don't
it's
know.
virtual.
Well, that's true.
Mm.
I haven't had, I guess I haven't really been approached for a virtual, down in some southern county, but yeah, my license is good throughout Illinois.
That's an interesting thing that happened for us with COVID is the state lines were erased and we could help people anywhere because it was a shortage. So if someone's in Iowa and they want to do virtual work with us, we can still bill insurance, which was interesting.
Nice.
Yeah.
So that's a change. Okay.
Yeah. It hasn't gone back yet. It's part of the CARES Act.
Yeah, there's certain states that kind of gone back, and then it's kind of right now still being debated and tossed around.
I think it's a great idea because there seems to be a shortage of mental health professionals. So that's a great idea to expand people's access by not being limited to the state that they live in.
And what would you like to say to someone who is considering divorce?
Well, first try marriage counseling. See if you can fix it. Before I take you down the path of dissolving your marriage, see if there is not a way you can keep it together for yourselves, for your children, if you have them. So that would be the first thing. And if you've tried that and it hasn't worked and you're convinced that divorce is what you have to have, then I would talk to several attorneys and see who you feel most comfortable with, who you think will be able to be your best partner through the process.
And, one thing I'd just like to end with is, and reiterating what you said is trust yourself when you're working with an attorney. And if you don't have a good feeling and you keep going against that, it's just going to cost you a lot more money. So make sure you're working with someone you feel good about.
Right. Yeah. Listen to your gut, not maybe your Greek chorus. A lot of people put a lot of fear in people. You got to get a barracuda, protect yourself. That's not a great way to start the process. Fear-based and not paying attention to how you feel about the attorney that you're actually talking to.
And in the end, whatever's legal usually wins out. Not just attacking people or going after.
Well, I was also going to say, if you have kids together, keep in mind, you still have to have a relationship with this person and it has to be.
Absolutely. Yep. Yeah. You don't want to, the saddest thing would be to go through a divorce and just be so negative and angry and hurt that you can't even be in the same room anymore. So your children are faced with, oh my gosh, who can we invite to graduation or the wedding or this ceremony or that ceremony, because everybody knows that the mom and dad can't be in the room together. That's terrible. But some people get they get so negative and just stay there, and then it really affects everybody's life, which is terrible.
We always say divorce doesn't happen in a courtroom, it happens in your heart. And some people are divorced before they're legally divorced, and some people are married long after they're legally divorced.
Right. Yeah, that's right. I remember you saying that in one of the podcasts. And I remember, there's so I read about a concept, negative intimacy. I think it was from it's called The Good Divorce by Constance Ahrens. And she talks about negative intimacy, meaning, like if you can't have positive intimacy, then somebody will, okay, if I can't take that, I'll at least take negative intimacy. And that's that ongoing negativity and the inability to peacefully let it go and move on. Staying connected, staying divorced or staying married in your heart in a negative way.
Well, Margaret, I want to thank you for being on our podcast today. We're definitely going to put your links to your website and also the international collaborative resource on this podcast episode.
Perfect. Thank you very much. And thank you for the work that you guys do.
Thank you. We want to thank all of you for joining us today on Couple Synergy. Our passion is in helping couples and people have happy and healthy relationships. And this podcast gives us a fun way of bringing our knowledge and expertise to you, our listeners. For all of you listening, please let us know how you enjoy the show. If you have any questions, comments, or topic suggestions, please email us at contact@couplesynergy.com. For more information about Couple Synergy and our programs such as Relationship 101, the home study course, the Couples Weekend Intensive, and our premier coaching program called Couple to Couple. Look us up online at couplesynergy.com.
And if you know someone who could benefit from this episode, please download it and share it. And thank you for listening.
Until next time, synergize your life and synergize your love.
You have been listening to Couple Synergy with Dr. Ray and Jean Ketkodian. Couple Synergy was recorded, edited, and produced by Dr. Ray and Jean Ketkodian. Voiceover and music entitled Breathe and Let Go was recorded and composed by Gina Gonzalez.